Is the federal government allowed to define marriage as only between one man and one woman and discount completely same-sex marriage accepted by the states? To find out, you have to read U.S. versus Windsor, but it's 35 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read. Normally, I cover New York Court of Appeals cases in 5 minutes or less, but this episode is part of a special series I'm doing on LGBTQ plus cases of interest, and this is an important one. This is an episode on the case of U.S. versus Windsor. The citation for this case is 570 U.S. 744, published by the United States Supreme Court on June 26 of 2013. The issue in this case is the constitutionality of the Defense of Marriage Act, which defines marriage as specifically between one man and one woman for the purposes of all federal statutes. So what you have to understand to appreciate what's going on in this case is, first of all, the Defense of Marriage Act. It had 3 sections. It's been repealed now by President Biden, but the Defense of Marriage Act had the second section and the third section are the important ones. The second section says that no state's required to accept the marriages recognized by a different state. So if New York recognizes same-sex marriage and Utah doesn't, then Utah doesn't have to respect and honor the marriages of New York, which may be same-sex marriages. The second important part of DOMA, which is Section 3, and that's the important part for this case, is the definition of marriage. And it basically says that for the purpose of all federal statutes, and there are thousands of statutes that are impacted by the term marriage, that the meaning of the word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers to a person of the opposite sex who is a husband or a wife. That's the important part of DOMA for the purpose of U.S. versus Windsor. The other part of the case, the other law you have to kind of understand a little bit about to appreciate what's going on here, is the Fifth Amendment to the Constitution, which is long, but for the purpose of this case, says no person shall be deprived of life, liberty, or property without due process of law. And cases have held, once even that I've discussed in this channel, that the due process of law has a substantive component, which means that there are certain fundamental rights that people have in this country that the government can't just infringe upon willy-nilly without high bar, either rational basis or strict scrutiny. We'll talk about that in a little while. The facts in this case are the plaintiff and her same-sex spouse were together since 1963. They lived in New York. They lived in New York State. They registered as domestic partners when that was allowed in New York in 1993. And in 2007, when New York State did not have a legal same-sex marriage, they went to Canada, to Ontario, and got married, and then came back to New York, where their marriage in Canada was recognized. In 2009, 2 years later, the plaintiff's wife died and left all of her property, all of her estate, to the plaintiff, her spouse, in New York. But according to the United States government, which had DOMA, they didn't consider her spouse because a spouse means a member of the opposite sex. So instead of being able to leave all of her estate to the plaintiff, the IRS charged her approximately $360,000 of tax for receiving this gift. She challenged it, and basically this whole case of U.S. versus Windsor is an IRS refund action. She's saying, you improperly billed me, I paid it, I want that money back because you shouldn't have charged me for it. That was my wife who died. And I was entitled to the exemption for a spouse who dies. Okay. So what happens during the course of this case is the plaintiff sues, saying this is a violation of equal protection because you're treating my marriage differently than my neighbors across the street who are heterosexual couple that are married. Plaintiff sues, and while the case is pending, President Obama, who was the president at the time, says, I don't agree with DOMA here. I don't want the federal government to be prosecuting this, to be on the other side of the case here from Ms. Windsor. So he instructs the Attorney General that he doesn't agree with the constitutionality of DOMA, and so the Attorney General backs out and basically gives it to Congress to defend. And they've done this before in a bipartisan legal advisory group called the BLAG. Basically, there's an intervener from Congress to defend the constitutionality of this congressionally passed statute. And the questions before the Supreme Court are 2 principal questions. The first is this a proper appeal? does the bipartisan legal advisory group have standing to sit in the government's shoes and oppose what's going on here? Or is there no standing? Is there no real case or controversy? Because the Supreme Court is only allowed to, under Article 3 of the Constitution, the judicial branch is allowed to adjudicate cases or controversies, not something where all the parties agree that it should go to that court. That's not what the court system is about. And the second question they have to deal with is the constitutionality of DOMA. And this is a close case. This is a 5-4 majority case. And it's a case that I could see coming back in the fairly near future the other way, based upon the constitution of the currently composed Supreme Court. But Justice Kennedy, writing for the majority, 5-4 decision, says, first of all, there is standing because the federal government, Obama said, we don't want to defend the constitutionality, but I'm instructing them not to give you back the money. So there is an actual case here. There's an actual controversy over the money, according to Judge Kennedy. And as to the constitutionality, he says this is a violation of the Equal Protection Clause of the Fifth Amendment. And the reason why, the Due Process Clause, the Equal Protection part of the Due Process Clause of the Fifth Amendment. And the reason why is he says what same-sex marriage being acknowledged and accepted by states does is it elevates the marriage. It gives the dignity to the marriage. What he actually says is, this is a quote. He says, the state's power in defining the marital relation is of central relevance in this case. Here, the state's decision to give this class of persons the right to marry conferred upon them the dignity and status of immense import. When the state used its historic and essential authority to define the marital relation in this way, its role and power in making the decision enhanced the recognition, dignity, and protection of the class in their own community. So the intent of the state is to elevate this relationship to a marriage, the same as heterosexual marriage. On the other hand, Judge Kennedy says, look at what the Defense of Marriage Act, the intent is. Even the name, the Defense of Marriage Act, defense from what? And he looks at the evidence here, which he talks about the way that we glean intent is the House report that accompanied the statute says it's necessary for Congress to do what it can to defend the institution of traditional heterosexual marriage. That DOMA expresses both moral disapproval of homosexuality and a moral conviction that heterosexuality better comports with traditional morality. That and the fact that it's called the Defense of Marriage Act. He finds that the intent is to diminish, is to degrade and demean the relationship between these same-sex married couples. He writes, what the state of New York treats as alike, the federal law deems unlike by a law designed to injure the same class the state seeks to protect. So essentially, the purpose is to discourage enactment of state same-sex marriage and restrict the freedom and choice of couples married under those laws if they are enacted. It's to treat same-sex couples as second-class citizens, even though they're married under the same statute in the individual states that they come from. So he looks at that and says, you can't treat people differently under the state law that they're married in the same way. And as a result, he says that's not a legitimate purpose. To demean a segment of the population is not legitimate, and there's no legitimate purpose to be gleaned from that, and therefore it's unconstitutional. Now, of course, in these cases, there's always a dissent, and here there's three. There's one by Judge Scalia, one by Judge Roberts, and one by Judge Alito, and they all basically say there was no standing here, and this is constitutional because it's not a fundamental right, and they don't agree with the standing issue of Kennedy because they say that everyone's on the same side of the coin here. The federal government and Miss Windsor want the same thing to happen, and that's not proper standing. It's not a proper case or controversy. So that's the case of U.S. versus Windsor, United States Supreme Court, 2003. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.